Good day, everyone. This is the WSIB Legal Side Podcast with Richard and Paul. Today, we're honored to have Ms. Durrani from Injured Workers Consultants, who will be talking about the age 65 limit to WSIB benefits and the legal and lobbying campaign that IWC is quartermastering to try and reverse this statute in the Workplace Safety and Insurance Act.
Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal with a specialization in workers' compensation and human rights law. If you want to reach out to either one of us or be part of our podcast, like our special guest, sorry, I'm going to butcher your name, you can contact us through the links below. And as Richard said, this week's topic is Lobby Day, which is about age discrimination. And we have a special guest speaker, and we're going to talk about this age discrimination issue specifically that, and I just want to make a clarification that from 1915, when the first Workers' Compensation Act was drafted in the legislature by Sir William Meredith, who was a conservative, and the government that passed it was a conservative government. From that day on, injured workers received benefits for as long as their disability lasted. So if you were like 80 years old, 90 years old, you received benefits. Then, for some reason in 1990, the Ontario legislature broke from that principle and said you get benefits to age 65 and then it stops. And then I think that's about it. Is that right? Do you want to fill any gaps I'm missing? Sorry, I've only had one cup of coffee.
No, I think you've captured it. Prior to 1990, there was a lifetime as pension for life system that was then changed to a wage loss system, which then brought in this age 65 cutoff. And so currently, lost wages benefits end when a worker turns 65. And if they have an injury at 63 years or older, they're only entitled to 2 years of lost wage benefits. So it is quite a stark change from the origins that you just described, Paul.
Yeah, and I mean, like when I look at the principles, because I go back, I've studied it a little bit, and I don't have it in front of me, but the one thing that's missing when people talk about the history of Meredith's principles and that was what he said was the purpose of the workers, a true or a fair and just compensation law, which is the purpose is to prevent workers who have been injured or made ill by their employer's workplace from becoming a financial burden to their family, friends, and they say society, but I specifically state taxpayers, specifically meaning if there's no workers' compensation, then workers end up on social assistance programs. Ontario works ODSP. Why should taxpayers have to foot the bill when work injuries are, so to speak, like car accidents or personal injury cases where the aggressor or the wrongdoer should pay? And that was the whole basis of the system. But in my view, it seems since about 1990, the government's veered right away from the Meredith principles and the purpose. In fact, I was surprised to see when I looked at other laws in Canada, Alberta posts in their law right in the purpose Meredith's principles. Ontario doesn't at all. It's almost like they're ashamed of them or something.
Hmm. That's a really good point. And not only has the law veered away from the founding principles with respect to these age limits, I think our fundamental position is that the law as it stands is just really out of step with how people work, and how people arrange their working lives today. And that's a really persuasive reason why the law needs to be amended to reflect that. So it is just really completely veering off from foundational principles, but it's also, I would say, pretty out of step with demographic and statistical realities, which I'm sure we'll talk a little bit more about today.
Like I know when my mom, and I think it'd be no offense to Richard, but I think it's Richard's generation. That generation, it was expected you retire at 65. In fact, only recently, I think, and correct me if I'm wrong, Ontario Human Rights Code and the Canadian Human Rights Code specifically said, hey, you can't just you can't what do they call it? Mandatory retirement at age 65. They stopped that now because most people, with the exception of myself and injured workers, are normally healthy and can work beyond age 65. And especially when we have, what do they call it, a brain drain or a labor shortage? Why would you push somebody like Richard, who's been around for a little while, right, Richard? Out of the
Forever.
system, yeah, with all those decades of experience, why would you push him out of the system, right? And then bring somebody like he does twofold things. He gives his years of experience, but then while he's still working in his, older years, that experience is transferred to the younger generations. That seems to be, in my opinion, lost to some degree if you're hanging on the 65 retirement.
Well, to your point, mandatory retirement in this province was outlawed in 2007, and that was a reflection of the fact that, just to your point, a lot of people weren't really retiring at that age. But the WSIB was granted a specific exemption from that, so was able to maintain these age cutoffs. And so even though the Human Rights Code, was updated to explicitly prohibit age-based discrimination, there was a special carve-out for the WSIB, and that at the time, in researching and trying to understand this issue more, we came across submissions made by the Ontario Human Rights Commission, and they were really strongly opposed to this exemption because a core message of their submissions was really that it sent a message to older workers that they are essentially of lesser worth. And I think the point that you're making, Paul, is that no, in fact, they have important contributions that need to be recognized, and the fact that they should just have the liberty to choose when they decide to leave the workforce. But in any event, that even at the time, I think that was a pretty controversial carve out, and the government obviously ignored recommendations from the Human Rights Commission on that point, and so the age limits were just kept in place, unfortunately.
Yeah, it's the only status thing. The Human Rights Code, I think, has 12 or something. I should know 12 statuses that you have to comply with the code. One of them is age, disability, so on and so forth, family status. And it's the only one, and I believe Ontario is the only one that exempts any discrimination based on age. And, as I'm getting up there in age, I'm kind of getting offended, not just for the issue of the LOE benefits and that, but for other issues, retraining, things like that. And I'm just spitballing here is they can sit there and discriminate against Richard or me, even if I'm not age 65, if I'm 61, and return to work and go, and that to me, it's an open book in a way for that exemption in the Workplace Safety Insurance Act that I don't like, which I believe it's section 2, as well as another point where if they go back to pre-1990, there is no discrimination at all outside of the paying of benefits, right? Like providing of the services.
So, what legal procedure is Injured Workers Consultants currently engaged in?
We currently are representing a number of workers with WSIB appeals, so at the appeals resolution officer level, with the goal of eventually having all of the cases heard together in a batch, so to speak, at the tribunal. Because I think just from a resources perspective, it makes sense to hear all the cases as one, and because we're essentially making the same argument. Obviously, there are factual differences in each case, which are obviously noted in submissions, but ultimately we're making the case that the law right now is unconstitutional and that it should be the current legislation should be repealed, and on the basis that it violates the charter. And one of the other reasons why we want to have everything heard together is because we plan on relying on expert expert data and expert submissions to support that position that the age cutoff is increasingly arbitrary and creates a one-sized arbitrary cutoff for everybody, regardless of their personal circumstance, and is solely based on age. And so the idea is to hear all of these cases as one to demonstrate to the government really that this is an issue that many workers are experiencing, and that it makes the most sense to address them all as a whole through a constitutional challenge. So that's the legal strategy in a nutshell. So we're hearing from workers more and more as our campaign reaches more people. We get people calling us and saying, well, yes, I'm approaching the 2-year limit for my benefits, or I'm approaching age 65. What are my options? And, I think the message is right now, well, the one thing that we can do is to try to challenge the law itself. And we recognize that that's a long process. Obviously, that's not something that's going to happen quickly, but the hope is that while we continue to assist workers with their appeals and build this pool of workers for a batch hearing process at the tribunal, we'll be able to engage in more systemic public advocacy and direct engagement with our legislators
Do you
on
have
this
any
issue.
do you have any idea when you'll get to the tribunal?
Um, I don't. I mean, I think we have some at the tribunal now that are on hold, um, pending outcomes from other cases, and we're in discussions with the tribunal around that batch hearing process I referenced. So I don't know when that's going to
So
proceed at
theoretically,
this
it should
stage.
be next year sometime.
Most likely, yeah.
Right.
So if I have, or if other representatives or injured workers themselves are self-represented, and they're like, say right now, or they're going to be shortly going to the tribunal and on their own or with reps challenging the age 65 issue, if they want to join like a class appeal, I guess you'd say, at the WSIB, what what should they do? Should they like notify the WSIAT, hey, there's another big thing going on with this actual issue, and can you hold mine and put it with that one? And then should they get a hold of you, or should they just get a hold of IWC?
I think at this point, the best course of action would be, yes, to get in touch with us.
Hmm.
We are trying to connect with different advocates from across the province who are dealing with these kinds of cases in the hopes that we can coordinate together. So, yeah, we would suggest reaching out to our legal clinic, and we'll have a discussion about where we're at, and yeah, talk about how we can connect their clients or workers with our um, broader batch or class action group.
You
I guess
know,
it's not really a class action, but it's sort of analogous. Yes.
that
We
class.
have
Yeah.
we have you've scheduled a lobby day. Can you tell us when that is and what it is?
Sure. We have a lobby day scheduled for November the 25th. Uh, at Queen's Park. Unfortunately, we have a very early start. It's going to start at 7 a.m. in the morning. Apparently, it can be difficult to book space at Queen's Park, so that's what we could get. But really, what we're trying to do is bring the issue directly to MPPs. So the purpose of the event is to have MPPs attend in person. Um, to have, some pastries and coffee early in the morning, while we also ourselves as advocates and more importantly injured workers who are impacted by this issue, and just broadly who are impacted by the workers' comp system, can meet and speak directly to their MPPs. And we also hope to have some of those workers present or speak at the event, just to express the impact that this particular law has had on people's personal and financial lives. And on the day, we will also be presenting or releasing a report where we outline the age cutoff issue, what it is, and why we think it's problematic. So there will be a press conference after the reception event at Queen's Park, where we will speak to this report, and people will get to hear from some of the workers we represent, and hear firsthand what this age cutoff means for people.
When is it going to be over? Like it's 7 a.m. till when about?
It should wrap up at 9:30, I believe. I think
Okay.
that's the time slot we have. Yeah, and then there will be a press conference after that.
So people watching this podcast who want to get involved, I assume they can either contact our office, Fink and Bornstein, where our email is listed on the podcast, or they can contact injured workers consultants, and somebody there can assist them in taking part in the November 25th activity.
Absolutely, yes. If you contact our office, we will um, and if you'd like to attend the event, we will add your name to the list. We do have to keep track of who's attending, so if you do want to attend, it is advisable that you contact us just so that we can let Queens Park know in advance who's coming. We also have information on a website called Injured Workers Online, which provides people with links and resources about things and actions they can take, including contacting their MPP, and emailing their MPP, encouraging them to attend the event on the 25th. We understand that not everybody is going to be able to come down to downtown Toronto at 7 a.m. on the 25th. So
Rush
the
hour.
next, yeah, rush hour, exactly. So the next best thing is to encourage your MPP to come out and meet with other workers and engage with us on the issue directly.
And I think you guys have a link or something where the injured worker can key in their address and it will tell them their MPP and then they can call their MPP and it has like a templated speech to speak to their MPP, I think, right?
Yes, absolutely.
Yeah. Yeah, we'll
Um,
post that in the show notes. Yeah.
yeah.
The other point I wanted to bring up quickly with Richard too is that Richard, you had challenged the age issue a few years ago, and I remember another friend of mine, a lawyer or a retired lawyer, he had raised the point about. He said, "Okay, yeah," but he said, "You know what, Paul?" He said the arguments that the judge had made or the panel of judges had made on this Section 1 charter thing because they said it's a Section 15 charter violation. Yes, we agree. However, it's justified under Section 1 because they say that it's demonstrated in a free and democratic society, specifically with injured workers. Anytime there's anything like that, the courts always fall back on the historic trade-off. And this is where I get my backup because the courts have made a serious error with that that up until 1990, as we said, injured workers had a right to workers' compensation for as long as the disability lasts. And that changed in 1990. There was a famous case that the Supreme Court of Canada issued in 1997, 7 years after the change in the law. And the Supreme Court referenced an Ontario case, Medwid v. Ontario, which was a 1988 case. And the Supreme Court, in my opinion, mischaracterized the current status in Ontario of workers' compensation, being the historic trade-off, right? Where workers enjoy security of payment. I mean, in my opinion, I wouldn't say you have a security of payment when you turn 65 and they say you're done. That's just, I mean, it's kind of splitting hairs a bit, but I think that's an important point in argument for the Section 1 thing is that the courts are saying injured workers have a historic trade-off, which is they have a right to benefits because they lost the right to sue their employer, and employers get a right to immunity. But I'm like, okay, well, if I'm forced back to work, which is another subject, or in the case of age 65, I don't get anything, or I get very little. There is no right anymore, or the right is significantly reduced. And I know the courts have been coming when it comes to private insurance, and I know this isn't insurance, it's different, but I would say it's similar in ways in the way in courts. But the courts have become very, how would I say, sympathetic or understanding of problems with big corporate insurance companies, how we say is gaming the system to deny claims just to increase profits. And that's something that should be looked, or I hope the courts look at that as well, and saying if private insurance companies are doing, and government insurance companies, then workers' compensation boards can and probably are doing it too.
If I can just do some history. So in the early 1900s, that is say 1900 to 1910, for the first time, judges in the United States said that the employer doesn't have to be negligent in order to sue the employer. They started to say if you were injured at work and it wasn't the worker's fault, you could sue. And the companies were livid over this because all of a sudden they had to get big insurance to pay for being sued. So that's the start of workers' comp. And the initial workers' comp payment was 5 years in duration. The only exception to the 5 years was that if the worker died, because the expectation was you, the injured worker, even if you lose a limb, you should be able to get back to work after 5 years, whereas the person who's dead is dead. So companies such as Pullman, which is one of the largest manufacturers in the early 1900s, they made cars for passengers and ran the cars for passengers. They would not hire anyone who had a family because they didn't want their insurance comp to go up. So their view was let them die. There's very little money that's going to be paid out. The comp system that came into Ontario and then Canada in 1914, Paul's right, it paid until death. The problem, if you think about it, though, is let's say you lost your arm in the old system, you'd get a 40% pension. You're going to be life and death using Canada Pension Plan and old age security to be earning the same as you were. So let's assume that you're working for minimum wage or just above it, say today $17 an hour, and you're able to survive on that. With that kind of pension, with CPP and old age, you're going to be well below what you were making. And you're going to go into further poverty. And that's what's happening to the 8 or so clients that we're putting forward, which is it's all very nice to say, yes, it's reasonable to cut people off at age 65, but these people are thrown into poverty for no reason that they have any control of. So let's take the example, you lose an arm. You're not educated, you lose an arm. Your ability to make earnings and to get employed are very minimal, and yet you'll be forced into poverty. So that's the argument that we're making in part at the tribunal and then the courts. And let me talk about the case we did, which was about 12 years ago. We actually started 15 years ago. The um, the percentage of workers who are working past 65 was 9%. And one of the reasons the court gave, they said, well, it's not an unreasonable law because 91% of workers retire anyways. So the statistics I've seen lately from IWC's statistician are it's almost 30% are working past the age of 65. So what you're essentially doing now is you're impoverishing 30% of the injured worker workforce that hits 65 because they're not able to continue earning and they're not getting WSIB benefits. It's the impoverishment that we argued in the court the last time as well, which was the worker had a job. He was going to work for his brother-in-law. He had the skills to do the job before he was injured, but with the injury, he just couldn't keep working. So he's lost all that money. So my argument would be is unless the worker's been investing in NVIDIA, the computer programming company, has made a few $100,000 on the stock market, they are in a lot of trouble. And that's one of the reasons why we have 8 clients that want to attend November 25th and 8 clients who want to be part of the case.
Agreed, and I'm glad that you brought up that case, and it feels strange to be talking to the person that litigated that case because obviously it's kind of the foundation of what we're working from. But yeah, I mean, essentially our approach is that, the legal arguments that were made in Guthrow are, we're essentially making the same arguments. We're just saying that the statistical landscape has just changed so drastically, as you pointed out, Richard. And I just wanted to add just a little bit more context with the stats as well, because not only are, I mean, as you can imagine, people staying in the workforce past age 65 has also meant that there are more WSIB claims made by that cohort of people. So just looking at numbers that we were able to obtain, in 1994, there were 4,430 claims registered for workers aged 63 and up, and you compare that to 16,784 claims registered in 2024, which is a really, really significant increase. That in and of itself, this is data that we were able to get from the WSIB, showing clearly that people are working past age 65 and as a result are um, engaging with the WSIB and needing benefits from the WSIB.
Let me just make one more
Um,
comment about lobbying. So the injured workers did a very aggressive demonstration and lobbying campaign in the late 70s and early 80s, in part because they were two ethnic groups that lived together, Portuguese and Italians, and in part because they were the people who were being injured in construction trades. And eventually their lobbying led to the Weiler Report and the reconfiguring of the Workplace Safety and Insurance Act, which in those days was the Workers' Compact or Workmen's Compact. Alec Farquhar and I and a few other lawyers had lunch yesterday, and it always brings up the following, which was on May the 29th, 1978, Alec and I are at the Labor Ministry on University, and we're in a demonstration, and the injured workers who are all with canes, they want to get into the Labor Ministry to talk to the Labor Minister about the fact that they're being paid so little. And the police start beating them back. So we get a full-scale riot. I run away, and Alec Farquhar runs away from the riot. And the reason Alec runs away is that he's supposed to be called to the bar in a month or two, and he doesn't want to get canceled by having a criminal record. I run away, and the reason I remember the date is I'm getting married the next day, and I really don't want to be in jail on my wedding day.
That would be
uh,
funny.
May the 30th. So I ran away. Andy King stayed and he got arrested, but eventually he was acquitted and became a big labor lawyer for the USW. But that was the beginning of demonstrations by injured workers, including taking over the legislature at some point in the mid 80s to force the government to change the law. And my final story on that is they're having these committee hearings with the new proposition, which is to go to the wage loss system as opposed to the pension system. And I'm opposing it. And so is Nick McCombie at the time, who was, I think, working for Injured Workers Consultants or IAFCO, one or the other. He later becomes a vice chair at the tribunal. And we're both opposing it. Everyone else is sort of milquetoast on it. And I've got a lobbyist person who we hired to help us oppose it. And the panel hearing our submissions actually swore at me, which kind of shocked my lobbying person. She said, I've been lobbying all these years. I've never heard the panel start to swear at you. They called me some defamatory name because I said the system stinks and it's going to stink. And I can say after watching it for the last 35 years, it does stink.
But look at it now, Richard. Like, look at what's happening with the board and employers. They've given 8, $10 billion to employers. It's, as we all know, it's Doug Ford's cash cow. So
They have the lowest rates in the world for WCB. There's nobody
that's the
lower
thing.
in the entire world.
I argue that how can you honestly say as a government organization or a nonprofit, whatever, that the model they're using right now is they went from an alleged unfunded liability, whatever, to a surplus of almost $40 billion, and at the same time reducing their sole source of income by 50%. There's just something funny or smells funny in the state of Denver. If you
I'm
remember
gonna
that saying.
talk to you about this after today's podcast. So we've been going now for close to 30 minutes. So I want to thank our guests and everyone watching. And hopefully, I know we're going to see everybody next week. Take care.
Take care. Thanks.
Thank
Thank you
you.
for coming.
Thanks for having me. Bye.